Will your children be able to testify at the master's hearing? Hi, I'm Alicia Kinchlow, the owner of Kinchlow Law, a family law practice based in the Philadelphia area. Now, one of the questions that I often get is, will your children be allowed to testify at the master's hearing? Before we dive into that, I just want to explain a little bit about what that is. All right, so when you first file a complaint for custody in the state of Pennsylvania, most of the time it's going to go before a master. And a master is what I call an attorney who sits like a judge. So they have the ability to make a proposed recommendation with the oversight of a judge. But what they try to do is try to help the parties come to an agreement. So sometimes what they'll do is take information from both sides and make a proposed recommendation or an interim order, which is going to last you until you get before the judge. The proposed recommendation is what they would be considering to be the final order if one of the parties do not file exceptions, which means they don't take exceptions to what the recommendation is. Now, the master will also hear cases in situations where there is a petition for modification of a current custody order. And in that situation, they do sometimes the same thing. They will try to get the parties to come to an agreement, kind of figure out what the outstanding issues are, and then send it to the judge. These hearings typically are on the record. Now, sometimes they're called conciliation hearings in some counties, and some of those are not on the record. So you want to be careful, you want to be prepared for these things. Now, sometimes when we have these hearings, parents or parties want the children to be interviewed or they want to be able to have their children testify. Now, across the state, generally children are not testifying in master's hearings. In fact, if you want a witness who's other than the actual parties to the case to testify, you generally have to make a request well in advance and give notice to the other party. But it can be done. So there might be situations in which maybe the testimony from the child is going to be extremely important to the case, where it's necessary, where either it's because they've witnessed certain things or because of the children's age or the child's age, their preference is going to play a huge role in either a modification or an initial determination or proposed order of custody. And what you should do in that situation, and again, in any situation where you want to have witnesses testify before a master, you want to consult the local rules for your county. Now, the state, all the courts across the state follow generally the same statutes, but with any type of case, whether it's criminal or civil, so basically family or criminal or anything else, there are generally local rules. So where the courts deviate a little bit or have more specified information on how they like to proceed in certain situations, the local rules are going to touch on that. So you want to consult with the local rules in your area about the proper format for requesting to have a witness, whether it's a child or someone else, to testify at a master's hearing. And you want to do this again well in advance of your hearing. This is not something that you want to spring up the day before or walk into your courtroom or hearing room with your child and believe they're going to be able to testify. So again, it can be done. You want to think about the situations in which it actually occur. If the child really is adding something of great importance to the case at this particular time, given the type of hearing that this is. And you also want to think about too, this is something that I think about when we're talking about these types of matters, is how long is it going to take from your master's hearing until you actually get a hearing before a judge. And if there is something of great importance, like a child who's 15 or 16 who refuses to go with the other parent, and there's not a lot of other ways to get that information or testimony in that's not hearsay, you definitely want to see what you can do to be able to make sure you have an order that is a good order for you and for the best interest of the child until you get before a judge. So again, check your local rules, contact the court administration if the local rules are silent about it, and find out what needs to be done in order to have your child testify at the master's hearing. As always, you want to consult with an attorney licensed in your state and who's familiar with the rules in your county about the facts specific to your case and the strategy of your case. Because again, all of it is part of the ultimate strategy of your case of doing what's in the best interest of your child or children. All right, I hope you found this video helpful. Make sure you hit subscribe, hit the little notification bell so you get a notification every time we drop a new video. We're doing one for every day of 2021 on custody, divorce, or support. But also go into the comments. Let me know what you think. Have you had a child testify in a hearing? Did you run into any issues? What did the county that you lived in require you to do to be able to do that? Were you able to just bring the child in? Were they lax on the rules? Are there any topics that you would like for us to cover in our daily videos? Because again, these videos are here for you. And until next time, take care.